Charged with harassment of a public servant. Normally, that's a third-degree felony. The range of punishment would be anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Welcome to the Gavel Updates.
2018 CR 9310. Thank you, Jason. You're doing it all today. State of Texas versus Travis Molden. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense.
Charles Bunk.
And are you Mr. Molden?
Yes, ma'am.
Thank you for speaking up. Mr. Bunk, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Molden, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
All right, Mr. Molden, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with harassment of a public servant? Normally, that's a third-degree felony. The range of punishment would be anywhere from 2 to 10 years in prison and up to a $10,000 fine. It's a court's understanding that the state is proceeding on the repeat offender enhancement allegation. It's that if that is proven to the court, then your range of punishment will be anywhere from 2 to 20 years in prison with a possible fine up to $10,000. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Molden, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, you'd agree that you've been previously convicted of a felony for enhancement. Punishment is to be assessed at 2 years in the prison. There are no applications. The state will take in consideration 2018 CR 10374. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
It is, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney?
Yes,
Did you
ma'am.
understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. State offer state exhibit number 1 with all the statutes.
No objections.
Mr. Molden, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
All right, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. With regards to the enhancement allegation, how do you plead? True or not true?
True.
All right, state, you may be excused to confer. All right, we're back on the record in 2018 CR 9310. With regards to the repeat offender enhancement allegation, state.
Your Honor, in lieu of we're missing a judge.
Excuse me, if you all are sitting behind the court reporter, need to move it to the end. Thank you. All right, state, are you waiving the repeat offender enhancement allegation?
Yes, Your Honor.
Any objections?
None.
All right.
So that's
Initial right there.
Yes. So, Mr. Molden, you understand then with the waiver of the repeat enhancement allegation, then your range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine?
So yes, ma'am.
Yes, ma'am.
Right. And knowing that change has been made, do you still wish to continue with this plea bargain agreement?
Yes, ma'am.
All right, thank you. Oh, no problem. It happens. It's a Monday.
It is.
If everything went well, it wouldn't be a Monday. All right, the court then will review State's Exhibits 1 and attachments for sufficiency. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
We believe he's deserving of the plea bargain. We have to follow it, and at the appropriate time, I have some
All right,
custody
I'm
dates.
sorry, just 1 second. Everyone, the court is on the record. If you cannot whisper, then that means you should not be talking. And if I can hear you out there, when you come before me, make sure you speak up so I can hear you. All right, defense.
I have, at the appropriate time, I have some custody dates to read into the record when the court's ready.
All right, the court will follow your agreement, sentence you to 2 years in the prison, give you credit for any time served, take in consideration 2018 CR 10374.
Okay, Judge. For the record, he was in federal custody from July the 26th of 2018.
Just 1 second. Excuse me. Hi. She needs to make sure she hears his custody. So if y'all will wait.
That's right.
All right. So he was in federal custody. What are the dates?
July 26th of 2018 through April 29th of 2022. And he was in the county jail April 29th, 2022 through May the 1st of 2022. Back in federal custody, June the 23rd of 2022 until February the 10th of 2023. And he's been here in the county jail from February 10th of this year until today. So I know the court can't satisfy the judgment, but he has the time to make the judgment satisfied once the paperwork is reviewed at the jail.
All right. And Caroline, I've written on the docket sheet.
She has the dates also. I've
Okay,
given
awesome.
them to her prior to the sentence, prior to the court.
All right. The court will give you credit for the time that you were in federal custody while this case was open. And the court will note for the record that the dates defense counsel has given to the court is July 26, 2018 through April 29, 2022 in federal custody. Then the Bexar County Jail from April 29, 2022 to May 1st, 2022. Then federal custody for June 22nd, 2022 to February 10th, 2023. And then the Bexar County Jail from February 10th, 2023 to the present.
That's correct.
Next, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
33, ma'am.
All right, so you're gonna have to start making better life decisions. Otherwise, you're gonna end up in prison or the Bexar County Jail for the rest of your life, or somebody's jail. You understand?
Yes, ma'am.
Do you have children? I'm sorry?
1,
All right, and how old is your child?
4.
I'm sure your child would like to see you, okay? All right, good luck to you. Thank you, Mr.
Thank you,
Vaughn.
Judge. And he had some property that was taken at the time. I'll be coming to court tomorrow with a motion to release some property.
All right,
All right,
thank you. I was calling 2022 CR 7154, State of Texas versus Raymond Ruiz. Could I have parties announced for the record for the state?
Jason Morgan, State.
Defense?
Romado Orto representing Mr. Ruiz.
All right, and are you Mr. Ruiz? Defense, you filed a motion to set bond. Do you have any witnesses?
Just, just ask the court to consider the case there, but I can ask the defendant on
I mean,
questions
it's
on the bond.
completely up to both parties if you have witnesses or not.
Yeah,
The
well,
rules of
just-
evidence do apply in
don't have any
bond
witnesses.
cases
we're,
where the person is remanded without bond.
Well, I have one witness. I can bring her in right now, Judge.
All right, if you have a witness you would like to call, the court is here to hear witnesses. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand if you'll state your name for the record, please.
Elizabeth Mateos.
All right, defense?
May I proceed, Your Honor?
Yes.
Ms. Mateos, do you know Raymond Ruiz Jr.?
Yes, I do.
Do you, how are you related to him?
He is my boyfriend.
You know, he's remanded without bond in this case.
Yes.
You're asking the court to set a bond?
Yeah.
Okay, and where do you work?
The group provider for group homes.
Okay, and how much do you make a week? Okay, and you have expenses yourself?
Yes.
Okay, and how much do you make, how much do you have in expenses a week? Yeah, you're almost breaking even.
Yes.
Let me ask you, you're asking the court to set a reasonable bond in this case.
Yes.
How would you're asking also the court to set a bond at least 40 to 80,000. Okay, how much of a bond can you afford in this case?
I don't know.
But you're still, will be trying to
Yes.
bond them out as your bond is set.
Yes.
And no further questions done.
All right, any questions?
Yes, Your Honor.
State?
Is it Ms. Mateos?
Yes.
Ma'am, so I guess you're the victim in an incident from October of last year, right? Or you're the alleged victim from that case?
Yes.
You understand? I'm sorry?
I'm sorry. There was an affidavit that I
Yes, so you filed an affidavit of non-prosecution,
Right.
basically saying that it didn't happen, right?
No, yes.
Okay. But you understand that case was filed, that you're listed as the victim for the case.
Yes,
from
I just
October.
found that out.
So this lady right over here, she's got to take down everything that's being said. So if I'm asking a question, if you can just let me finish asking the question,
Okay.
and I'll try to do the same for you. Now, you understand that the case we're here for today, that they're asking for a bond to be set for, that's not the same case that you were listed as a victim for.
That's correct.
Are you aware of the other cases that Mr. Ruiz is charged with?
Yes. Listen.
Okay, what do you think he's charged with?
Assault with a deadly weapon.
I'm so sorry. Can you make sure you speak up so I can hear?
I think it's assault with a deadly weapon.
Oh, and that's the one that we're here for today,
Yes.
for the bond hearing. Are you aware that he's actually been charged with those kinds of cases before?
Excuse me. I'm sorry.
Are you aware that he's been charged with those kinds of cases before?
Yes. Sir.
Did he tell you about those?
Yes.
And he's actually been convicted and gone to prison for them before, right?
I don't know about.
Now, on the date that this happened, I guess you talked with a constable, right? Was it Deputy Sanchez? Does that sound familiar?
I don't know what the names.
Okay, but you talked to some police officers.
It was at a convenience store.
Okay, and you talked to the officer on that day?
Yes.
And you understand the importance of telling the truth to the police,
Yes.
right?
Yes.
Do you have any children?
Yes, it is.
What children do you have?
I have a 12-year-old.
And are you concerned for your children? It's a 12-year-old son, right?
Yes. No.
Okay.
They have a good relationship.
I'm sorry, I couldn't understand what you were saying, that last part. What did you say?
They have a real good relationship, my son and Mr. Ruiz.
And I mean, that's not really what you convey to the officers, right?
What I read from the report, it doesn't sound like anything that I said that day.
Okay.
I mean, none of it adds up the same thing that what happened that day.
So when you said Mr. Ruiz had threatened to kill you and your son, that is not true.
No.
Okay. And
All right, and I'm sorry, just one moment. If this witness is going to deny what she's told the police, she'll probably need to have an attorney appointed to represent her. So is that your intent, to deny what's in the police report?
Yes.
All right. You want to ask another question of this witness?
we'll pass the question.
All right, any other questions?
I don't know further questions, Your Honor.
All right, may I ask one question? Is there any objection?
Okay.
How long have you known Mr. Ruiz?
I've known maybe about 10 years.
All right. And you say that you are a home health care provider?
Yes.
And are these persons that you take care of in your home?
No,
Or you go out to visit them?
Yes. Yes.
And are there any other children in your care other than this 12-year-old?
Yeah.
Do you have children that you babysit other than the 12-year-old?
Yeah.
All right, thank you so much for coming in. All right, any other witnesses?
Oh, Your Honor.
All right, Mr. Ruiz. All right, the court will hear argument. Defense, any other argument?
Because the only thing is that we ask the court to consider putting on bond. Usually when somebody comes in, usually the bond is doubled. That's what we're asking the court, in case of 80,000, bond of 80,000.
All right, request for bond is denied. I'll see you all back on April 3rd for jury trial.
Thank you, Judge.
All right, thank you.
We don't have a bond set at all?
No.
Not any bond?
And we're off the record, but Mr. Ruiz, while you're on bond, and I don't take any of these cases as true, but while you were on bond for aggravated assault with a deadly weapon, you then are charged with assault of a peace officer, another assault with a peace officer, and retaliation. And also a retaliation. So there will be no bond set in this case.
Thank you, Judge, maybe excuse.
Yes. Thank you.
The courtroom's attention centers on Travis Molden as he appears before Stephanie Boyd to enter a guilty plea to harassment of a public servant. Standing beside his attorney, Charles Bunk, Molden acknowledges the charge and the standard punishment range of 2 to 10 years. Prosecutors, however, seek a repeat offender enhancement that could raise the maximum sentence to 20 years. Judge Boyd carefully reviews his rights, the waiver of appeal, and the full consequences of pleading guilty. Molden confirms he understands and accepts the agreement, 2 years in prison in exchange for his plea. Tension briefly rises when the prosecution cannot immediately produce a key document supporting the enhancement allegation. Judge Boyd remains composed, giving the state time to address the issue. Ultimately, the enhancement is waived, restoring the sentencing range to 2 to 10 years. With that clarified, Molden pleads guilty, and the court imposes the agreed 2-year sentence in the Institutional Division of the Texas Department of Criminal Justice. The hearing then shifts to custody credits. Defense counsel details Molden's lengthy incarceration history, federal custody from July 2018 through April 2022, additional federal confinement in late 2022 and early 2023, and time in the county jail. After confirming the timeline, Judge Boyd grants credit for eligible federal time while the case was pending. Before concluding, she delivers a firm warning to the 33-year-old defendant about the consequences of continued poor decisions, emphasizing the impact on his future and his child.